Hello, everyone, and welcome to our morning coffee club. My name is Courtney Roca. I'm the Client Care Program Coordinator here at Legacy Planning Law Group, and I want to thank you for taking time out of your schedule to join us. As you know, today is about why do I want to avoid probate. We have our attorney and our paralegal with us. And as you can see, Bill is surrounded by a lovely group of women.
Good morning.
And before we get started, I want to go over a few items so you know how to participate in today's event. The webinar is being recorded and will last about an hour, including the question and answer portion. All participants' lines are muted. The questions can be submitted via the GoToWebinar questions box at any time and will be answered at the end of the presentation. The recording of the presentation will be sent to you approximately 72 hours after we are concluded. And please participate so that you have a better experience. Ask your questions, and we will be having a poll coming up, so if you could take part in that as well, that would be great. If at any time you're having any technical trouble or you have a question about what's going on or you can't hear us or anything like that, I will be available in the chat, so you can go ahead and throw your question in there and I will try and get that fixed for you. So now we'll start with an icebreaker question, which is a poll that we're going to be doing. And so that poll question is, what has been your level of experience dealing with the probate court? So I just went ahead and opened that poll. I have no experience, I have some experience, and I'm a pro. We'll go ahead and keep that opened. Like 7% have voted. All right. And I went ahead and closed that, and I'll share that with you guys. So everyone seems to have some experience with probate, whether it's as dealing with your own experiences or maybe watching someone deal with an experience. Everybody who has voted has some experience. It's good to know that nobody has no experience. And we have, I guess, only 2 pros on the call today, which would be our attorney and paralegal. I'd like to say thank you for coming to our morning coffee club and introduce Legacy Planning Law Group's attorney Bill O'Leary and our paralegal Jeanette Saville.
Well, good morning, everybody. I want to thank you for joining us for this this morning coffee. It's something that we started doing given this current situation that we find ourselves in. Hopefully, everybody is staying healthy and as safe as you can. And we thought this would be a way to sort of reach out to people through a medium that, you know, perhaps wasn't used as frequently as before we got into this situation. By the way, as to the poll, I do want to say I'm glad to hear that everybody's a pro, because if anybody's a pro, then you might be having some other problems. I want to go ahead and introduce Jeanette. Jeanette, you want to say hi?
Hi, everybody. Good morning.
Jeanette wears a couple of hats here at the firm. Number one, she is our office manager, so all roads lead through Jeanette, but she also is our estate settlement program paralegal. So she deals with probates and estate and trust administrations. And I think I asked her yesterday, on a scale of 1 to 10, how do you feel when you were handling a probate case, when you're working on it? She said an 11. So she loves this stuff.
That's my genre.
That's right. Before getting into what's probate, just back to the housekeeping items. Courtney mentioned this is going to take about an hour. My guess is it's going to take less than that because sort of what we are going to be talking about, Jeanette and myself, is more sort of high level things about probate, but I really want to open it up to questions. I mean, there is presumably a reason why you've gotten on this video call this morning at 8 o'clock. You could have been doing other things with your time, and we want to make sure we get to answering your questions, okay? So what I thought I'd do first is talk about a probate, because I think that's important as a frame of reference to help sort of answer the question, why do you want to avoid probate? First of all, probate is a very slow process. And back up, when I say process, what do I mean? It is a process that is a court dictated process. It's a court process. And so what does that mean? That means that that your loved one's estate, and by the way, when I use the term estate, I'm referring to everybody. It's not just really rich people. Everybody has things to pass on at death. That their estate is being handled or overseen by a judge. Overseen by a judge. Now there may be somebody handling the day-to-day of it, but it's being overseen by a judge. Okay. Well, so what does that mean? Well, once you're in the court system, it's hard to get out. And there are certain things that have to be done, and they're built into the system, they're built into the process, and we've got to go through those various steps. And there's only so much we can speed up the process, and more often than not, we're not able to speed up the process, but it ends up going slower than we hope or expect, and certainly slower than the client wants. And it's funny, sometimes I like to tell the story that, you know, when I'm meeting with family members for the first time whose loved one has passed away, and I'm talking to them about the process, the journey they're about to go through, and I tell them, look, this is going to take a long time. Okay, it's going to take a long time. In fact, the average length of a probate is about 9 to 15 months. And in fact, as Jeanette will tell you, we have a number of probates in this office that are into year 2 and a couple that are into year 3, if not more than a couple, because things sort of pop up out of nowhere that are unexpected. We have funky issues, assets that are a little bit sort of off, and we have to deal with those. So back to that meeting with the family, I will say, look, this is going to take a long time, and it's going to take longer than you expect. And so I just take a deep breath and relax and be patient with the process. And then I'll pick out a family member, usually pick on one of the men, if there's a man there, and say, sir, I'm going to have a gentleman's bet with you, which is when you call into the office 5 months from today and you complain, why is it taking so long? And I'm going to gently remind you of the conversation we're having right here in this meeting, where I'm telling you now, this is going to take longer than you expect, and you're just going to plumb forget I told you, which is okay. It's a long process, and so it gives rise to frustration, and that's just human nature. You want to get it over and done with. There is, you know, there are assets, there's money there that your deceased loved one wanted to pass on, wanted to give to you and other family members, and why can't you get it? Why can't you get it now? So it's a slow process. And so being a slow process, what does that often mean? No access to the money. So mom or dad, you know, had money in a bank account or an investment account, and it's sitting there, but you can't have access to it. Well, by golly, there are expenses that have to be paid, creditors have to be paid, you know, fees have to be paid, and so forth. But you don't have access to the money. At least you don't have access to the money right away. And so sometimes that creates sort of a cash flow issue with respect to at least the family member that is stepping forward to handle the estate as the executor, which we now call a personal representative in Florida, but I'm sure you've heard the term executor. They'll be handling the day-to-day, but they don't have access to the money. So that really is sort of the first issue or problem, I should say, with probate, is that it's a very slow process. The next problem is that it is costly and it is expensive. Well, there are a number of expenses that go into a probate, but what is by far the largest expense, aside from paying creditors? And you know, creditors, unpaid bills, they're entitled to be paid first before anybody gets any money out of the estate. Where does the biggest expense come into play? The biggest expense involves the fact that in Florida, in most every probate, a lawyer has to be involved. No two ways about it. So a lawyer has to be hired by the executor to represent them and to handle the estate. It's black and white in the law. I didn't write the law. We can talk about whether that's good or bad, but that's just a stark reality. In fact, it's funny, if you go down to the courthouse, and as you come in there, you turn to the left is where the probate desk is, the probate clerk's office is. There's a big sign on the counter that says you must have a lawyer, because people will often come in to try to open up that probate case themselves. Okay, well, how does the lawyer get paid? Because the lawyer is going to be paid for their service. Well, they are entitled to be paid a fee, and under the law, that fee can be based on how much money, how many assets the deceased loved one had when they died. And the fee is based on a percentage of that. It's between 3 and 5% of the value of those probate assets. And so, depending on what your deceased loved one had, that can be very costly. And it's again, we can have a debate whether that's fair or unfair. Really, that is not important. What is important is the stark reality that that's what it costs to pay a lawyer to handle a probate. And it's funny, from time to time, I will be talking to lawyers in other states, probate lawyers in other states that handle these kinds of probate matters. And because each state is different. And when they find out that I'm from Florida, they said, "Oh, you're from Florida. Oh, you're from the state where the lawyer gets paid between 3 and 5%, which is quite a bit higher than most other states." So Florida is notorious for two things. Number one, having sort of slow, protracted probates compared to other states, and two, being very costly to the family, but sort of rewarding to the lawyer. So it's the fact that it's slow and it's costly are the two main reasons or problems with probate, and the main reasons why we help people plan to avoid it, so that their family is not stuck, is not bogged down in the probate court system. So in addition to being slow and being costly, probate is public. It is public. So what do I mean by that? Well, when somebody passes away, the very first thing that's done is that their will, if they had a last will and testament, is filed with the probate court. Okay? So what does that mean? Well, anything that is filed with the court is public record. So anybody that wants to know can go down to the courthouse and pull out the file and look at the will and see what your deceased loved one said and didn't say. Or better yet, it's much easier than it used to be. You don't have to drive in your car down to the courthouse anymore. You can just go online and pull that answer up in probably 5 to 10 minutes. Well, when I talk to people about this, the fact that it's public, most people are private. They're private about they don't want their laundry hanging out there like that. They don't want their wishes laid out in public view. Even if they don't expect somebody from the local newspaper to come in and look at that, they don't want other family members to necessarily see. And in some situations, the client may say, I am not appointing my sister as to handle my estate when I pass away, because she did something 10 years ago and I don't trust her and I want to appoint someone else. But I'd rather her really not know that. And so then I say, look, then I think we need to help you plan to avoid being stuck in probate, because if that's the case, your sister is going to know. So probate is a very public process, okay? And then the last issue that we see with probate is that it can be messy. What do I mean by that? Well, aside from the fact that it takes a long time and things sort of pop up You thought that you had paid all of the bills and all the creditors were taken care of. Gee, a creditor pops up 6 months later. Maybe it's an unpaid hospital bill, doctor's bill, ambulance bill, whatever it might be. It can also be messy vis-a-vis sort of family members, okay? And so it's, I have to say, honestly, from the bottom of my heart, one of the saddest parts of what I do is to see families that break up, okay, that break up when a matriarch or patriarch of the family dies, okay, because maybe they felt slighted or what, or even if everybody was treated equally, money does funny things to people. Well, if the matriarch or patriarch's estate is stuck in the probate court where everything is publicly available, then that increases the odds that somebody may challenge things, and that challenge may be successful, okay? And it really is, I hear stories, well, I haven't talked to my brother in 22 years, ever since mom died, and it just makes my heart sink. And so that's why, I say, look, and a lot of times that is after the estate had to go through probate, because it sort of exacerbates maybe feelings that are below the surface. It's best, I tell people, let's see if we can plan to avoid this altogether. Avoid, this whole entire process that takes a long time, it's costly, and it's public, and it's messy. So that's a general overview of what probate is and some of the problems that we see with probate. And so what I'd like to do now is, Jeanette is really sort of on the front lines of a lot of these cases, and she really sinks her teeth into it. And I thought it might be helpful if she shared a couple of recent, we'll call them horror stories, probate cases we've had that really have had sort of difficult situations. So, Jeanette, you want to talk about that?
Sure. So we have our client, Sam, who contacted us. His girlfriend of 30 years passed away, Susan. Sam and Susan owned a house together. They didn't have joint bank accounts. They had their own separate bank accounts, but they did own a house together. Susan passed away, and she did not leave a will. Now, Florida, they were not common law married in Florida or anything like that. Susan's parents were both deceased. She did have a brother, Roger. Under Florida law, everything that Susan has in her estate goes to Roger. So Sam, her live-in boyfriend of 30 plus years, was entitled to nothing under the law. And luckily, Sam and Roger got along. Still get along. So basically what ends up happening is the court designates all of Susan's assets to Roger, and Roger is willingly and of his own free will giving everything back to Sam. But if Susan had had a will, or better yet, joint bank accounts or anything of that sort, Sam wouldn't have to be going through this, and Roger wouldn't have to be going through this, collecting everything and then passing it on to Sam. So that's the first horror story. The second one is Marie. Marie lived in Nevada. Her mother lived here in Orange Park, and she passed away. Marie had an estranged brother, Michael, who emancipated himself from his mother, Nora, when he was 17. And Marie hadn't seen him in, I think it was 15 years. But when Nora, the mother, passed away in Orange Park, she also did not have a will. It does not matter that Michael emancipated himself from the family. He is still an heir under Florida law. And Marie attempted to contact him. We attempted to contact him to get him to sign some sort of a waiver or disclaimer of his legally entitled part of the estate, so that Marie, who was the child that was still of the family, still Nora's daughter, would be able to inherit the whole estate. And he flip-flopped around and wouldn't sign it. And then a year later, we were contacted by an attorney he had hired. He decided he wanted his half of the estate. And he hadn't seen his mother in 15 plus years, hadn't spoken with her, hadn't spoken to his sister Marie. But under Florida law, probate law, he is entitled to that half of the estate. If Nora had written a will, she could have disinherited him as an heir, and Marie would have been entitled to everything. But because probate law is what it is, you do have an estate plan, whether you have a will or you don't. And Nora's estate plan was that she had 2 children, and they both get half of her estate.
And Jeanette, let me stop you there. In that situation, the long lost brother sort of surfacing, that wasn't expected at the beginning and was kind of a surprise. And I know our client was kind of upset by that.
Very upset, yes.
Yeah. And so how did our client react to that?
She wanted to fight it. She decided that she wanted to go to court and litigate against this and try to get the entirety of her mother's estate, because she felt that she was entitled to it and her estranged brother was not.
Mm-hmm. Yeah, yeah.
No. I have more. Do you want me to keep going?
Well, I tell you what. Why don't you share one more situation or story that we've experienced, and then I'm going to share one myself, actually. Okay.
Okay. So Andy contacted us. His mother, Diane, passed away in Jacksonville. Andy and his wife were the sole caretakers of Andy's mom, Diane. They lived with her. They took her doctor's appointments. They, were very much her caretakers. Diane did not leave a will. She had 3 children, Andy, Brian, and Carol. Andy contacted us to petition the court to be appointed as the executor of his mother's estate. It seemed reasonable because he and his wife were the sole caretakers of mom in her last few years of life. Brian, the other brother, and Carol decided that they wanted Carol to be the executor of the estate, and they basically bonded against Andy and got Carol appointed as the executor of Mom Diane's estate, which it turns out is very substantial because Diane was one of the sole heirs of her sister's estate, which was about $500,000 at that time. So there's a lot of money at stake here, and the siblings are fighting over things like wedding band sets and things like that, arguing over who's going to get that, who's going to get her car, who's going to get the pictures. They're not agreeing on anything. And the end result is Andy, after taking care of his mom for all these years, is not the one who is in charge of distributing her estate. That is his sister, Carol. Yeah. Because Diane failed to leave a will that appointed Andy as her executor. And Carol and Brian decided that they wanted Carol to be in charge. Now, Andy is getting all the bills and everything, is in possession of all of mom's personal property, and they're having to communicate from Andy to us as his attorney, and then we have to communicate with Carol's attorney, and then Carol's attorney has to communicate with Carol. And this is an example of an estate ripped this family apart. They won't speak to each other at all anymore.
Yeah, and share with the audience, if you would. It seems like, 2 or 3 times a day, I'll come by your office, and you're on the phone, and you're talking with, one of our probate clients that's going through a difficult situation, and it's almost like you're playing sort of part psychiatrist, having to sort of handhold, which is good, but when you have to handhold, that means they're not having a good day. So just share with people some of the sort of the experiences or feedback you've had.
We have another client whose father passed away and had a very old will there was 5 children total, and he named all 5 children and a grandson in his will and gave specific percentages of his estate to each. Well, by the time he passed away, his wife had predeceased him, one of his sons had died before him, and the grandson had died before him. And the whole sum of this estate was an IRA that held, I think it was $36,000 when we started this in December. This was a summary probate case, which is supposed to be a lot shorter, a lot easier. There's a ton of less requirements. It's a cheaper way to do probate in Florida. But because the will was so old, and 3 of the named heirs had predeceased the father, you had to go to court on this and tell the judge, here's this affidavit that our client had filled out, and she had to search up things like grandfathers and grandmothers of her dads, when they died, where they died, what their full names were. A lot of this she didn't know. This was just exhaustive, and she is still fighting to try and get this IRA distributed to her and her remaining 3 siblings. And it's been 5 months.
And I remember that. And the sad part is there was such an easy fix to that. Before their family member died, all they had to do was fill out a 1 or 2 page form called a beneficiary designation form on the IRA, and all of that would have been avoided. So, okay. So what I'd like to do is I'd like to share a story and then move on to talk about, maybe how this probate disaster can be avoided. I want to tell you the story of Bob, okay? This is actually a sort of a sad example where things were not made easy and smooth for the family. So Bob was an 84-year-old widower. He had 3 adult children. In fact, it was a son and 2 daughters. Now the daughters were in pretty good position financially. They both had very good jobs working out of the home. Also, their husbands were professionals, and so they really didn't lack for much of anything. But it was Bob's son. Bob was concerned about his son. That was the child he was most concerned about, because his son had sort of fallen on hard times. He was laid off twice in 3 years. Each of Bob's 3 children had kids of their own. And so between those 3 sets of kids, Bob was most concerned about his son's kids, because his son really was having a tough time financially, okay? And in fact, his son's kids were about to start college. So he very much was thinking of, gosh, if there's a way I can take care of my son and my son's kids, that set of grandkids. Well, Bob then got cancer, and the diagnosis was 6 months to live. So what he decided to do is, all right, I need to get busy and put things, down on paper and formalize them. And he wanted to give really his estate to his son and to his grandkids, his son's kids. Okay, so he wanted to give most of it to his son, but he also wanted to earmark son to those sets of grandkids, because they were about to start college and would help with college tuition. Okay, it was very important for Bob that the money go quickly to his son, because his son was on the unemployment line, and to his grandkids, because they had tuition bills coming due. He wanted that to happen, and happen quickly. So he decided to put a plan in place. What did he do? He got a will. He got a last will and testament, thinking that, well, this is going to solve the problem. When I die, I'll have a will in place. It'll say everything is going to my son and his children, that set of grandkids. My daughters are okay with it. They don't need the money, and they say, Dad, we know that our brother's having a tough time. We don't need the inheritance. We don't want it. So he did a will. And then Bob died several months after putting the will together. Now, when he died, his sort of entire estate, everything he had, consisted of a house, several bank accounts and like mutual funds, investment accounts, along with some stock. So if you put it all together, it was worth about $875,000. Well, after Bob died, his son, who was the executor in the will, discovered a sort of a cruel truth, which is, he's stuck in probate court. What's the big deal? Lasted 14 months. It lasted 14 months, which meant, his son couldn't get money that he needed frankly, he really could have used it. He was on unemployment. And oh, by the way, his kids had to go take out student loans. And to sort of add insult to injury, Bob ended up, well, Bob's son, I should say, as the executor, had to pay an attorney to handle it, $26,000 later in lawyer fees. So that really was the cost of Bob's mistake. And the tragic part is that in working with the attorney handling the probate, okay, Bob learned, or Bob's son, I should say, learned that his dad could have planned so much better, could have planned in a way at a fraction of that probate cost without the 14-month delay. You know, Bob's son wondered aloud why his father was never told about that solution. And you know, maybe the answer to that is maybe Bob didn't ask the right people. Okay, so what I'd like to do is go ahead and talk to you for a few minutes before opening up to questions, and I do encourage the questions about how do we help families avoid probate. There are several different ways to avoid probate, but what I like to do is focus, just given the limited time we have, on one way to avoid probate that we do very commonly, very often, okay? Particularly for somebody that's sort of middle-aged and up, you know, maybe 50, 60, 70, certainly. And that is with what's called a living trust. Some of you may have heard of a living trust. So what is a living trust? Well, think of it this way. A living trust is nothing but putting together a box. You are building a box, okay? And in that box, you are answering 4 very important questions in that box. Number 1, you are deciding who gets your stuff. Number 2, what they get. Number 3, when they get it. And number 4, how they get it, okay? Courtney, if you could hit the next slide, please. So it's who, what, when, and how. No, go back, please. There you go. So it's who, what, when, and how. So you decide who gets your stuff, what they get, when they get it, and how they get it. And it's within the context of a box, okay? Now, if you think about it, if you've heard of a last will and testament, many of you have, well, a will answers those same 4 questions, doesn't it? Sure it does. A will is a way for you to put down on paper the same 4 questions and the 4 answers. Who gets your stuff, what they get, when they get it, and how they get it. The problem is, you just heard with Bob's story that he had a will. He answered those 4 questions for himself, who, what, when, and how. Yet his son was still stuck in the probate court. So then how is a living trust different? If you had a living trust, which is simply an alternative to a will answering the same 4 questions, then your loved ones do not have to go through the probate court. Do not have to go through, so they're not stuck dealing with some judge, the 800-pound gorilla down at the courthouse that oversees everything, and that very lengthy delay. And so a living trust is a very commonly used way to see that that whole probate process does not have to be gone through by the family. Okay, so living trust. Some of you may have heard of that, and often when we meet with clients in the appropriate situations, we will discuss that as a planning alternative, and then the client decides what's best for them. Okay, so what I'd like to do in the next couple of minutes, again, before opening it up to questions, I just wanted to share with you real quick a couple of really sort of client-facing systems or processes that we have that I'm very excited about. The first is called the Family Estate and Legacy Program. So you see there, it's we've got a nice sort of visual of it, and it consists of 7 steps. Let me quickly tell you each of the 7 steps. This is somebody that comes in for estate planning to, you know, talk about a will or a trust. This is the journey that they go on. The first step at the top is what we call the organizer. And so this is where the prospective client puts information down in a concise format, call it a workbook. We call it our client organizer. They get it back to us before we visit with them initially. Then secondly, the second step going clockwise is what we call the goals conversation. So the goals conversation is where we are able to sit down and have the client tell us what their goals are, what's important to them, what they want to accomplish. Not only their goals, but their concerns. And let's see if we can't identify any obstacles that are standing in the way of achieving those goals or solving those concerns. We then move on with the program. We get to step 3. So we get to step 3. Once we are brought on board and the client decides to move forward with the planning, we call this the design and responsibility conversation. What is this? Well, at this stage, we're going to sit down and drill down and actually design the specifics of their plan. And let's say it involves a trust. Well, let's decide, who's going to get what and how are they going to get it? Because there are different ways that a loved one, if an heir, can receive an inheritance, let's say through a trust. There are different ways that could happen. And then the responsibility conversation. And this is sometimes an easy conversation, sometimes not so easy. And that is, let's figure out who's going to be responsible to do what. There are a number of different roles that have to be filled, whether it's a trustee, whether it's an executor, whether it's power of attorney, whether it's what we call a disability panel. A panel of people that will make the decision whether you are incapacitated, so we keep it out of the court system and even out of the hands of doctors. So that's step 3. We then move, continuing clockwise, the purple down there at the bottom, the document builder. Now we are getting busy. We are putting all of the legal documents together. We then come over to step 5. This is a step I'm a big proponent of, called the advisor coordinator. The advisor coordinator. And so here, if the client is working with a financial advisor, and if they come in and they're not working with one, we ask if they'd be interested in working with one, because we have people that we could put them in touch with to plug that advisor in. Again, it could be the financial advisor, the CPA. I believe in the team approach. Multiple heads, are better than one, and just benefit the client. The advisor coordinator is an integral step. We then get to number 6, the alignment process. What does that mean? You can have the best estate plan in the world. Let's say it's a trust. You can have the best trust in the world. If you don't properly align your assets with the trust, it's not going to work. And so we're able to sort of go into detail as to what that alignment process looks like with clients. And then lastly, the client care program is the last step in the Family Estate and Legacy program. It is a program that is designed for clients that don't view this as a one-off transaction, but want to sort of continue the planning process moving forward, so that if things change in their life, they can adapt their plan, and allows us to walk with them on their journey. And our solution to that is our client care program. So in a sense, the client care program may be the last step of sort of this planning phase, but in another sense, it's the first step to the next phase, and that is to change their plan moving forward over time. So that's the Family Estate and Legacy program that we offer on the planning side. Now, let's say somebody whose loved one has passed away, maybe not plan as well, or has an estate that needs to be what's called administered or settled. We have our estate settlement program. We have a 7-step process here as well. Real quick, step 1 is the snapshot. What is that? Well, that's the initial meeting that we have where we give the family, in this case, an overview of the estate settlement program, what's involved, the different steps, sort of the journey that they're going to go on, and see if the client then wants to actually bring us on board to handle this. If they do, we then go to what's called module 2, the legal module. So that's a separate meeting where they give to us all of sort of the legal documents, what are we talking about? A trust, a will, maybe nothing at all. What are the legal things that we have to deal with in order to get that administration started? Step 3, module 3 is called the assets. At that module, we help the client identify the assets and what's called marshal the assets. It's very important to get an overview of what the assets are, And at this stage, if the client's working with a financial advisor, we really plug them in and get their help, because they'll have a lot of this information available to them. We then move to module 4, critical step, the creditors module. As I said earlier, creditors need to be paid before the beneficiaries get their money. And there's an entire process, whether we're going through the probate or even if we have a trust where we're not in the probate court, we want to make sure that the creditors are paid, and there's a process for that. We then go to step 5, module 5, called the taxes module. This is a very important a part of the process. We often plug in a CPA. There are tax issues that have to be dealt with. The deceased loved one's final tax return has to be filled out. We, in all likelihood, will need a separate tax return for either the estate or the trust, okay? There are issues with the deceased maybe having an IRA. Well, we've got to make sure that that final RMD, required minimum distribution, is paid. And then there's an important tax step, which is, okay, assets that are passing to loved ones. Well, let's have them pass in a way that minimizes the tax hit on the loved ones, okay? If we skip this step, the loved ones may be stuck with a tax bill. Then we go to step 6. We've gone through steps 1 to 5, and if we've been successful, Jeanette, in convincing the family member who's serving as the trustee or the executor, hold off on making distributions until we get these other steps done, then at that point, we can make distributions. There are different things that have to be done there in terms of doing an accounting, and getting the beneficiary to sort of sign off on the distribution. And then finally, we go to the wrap up. And what I like about this, before bringing this to a close and opening up for questions, is, here we have 7 steps that you can see in colorful visual form as, as sort of a, call it a snapshot. So both here in the estate settlement program and the previous, the family estate and legacy program, clients find this very helpful. A lot of times clients will go into either the planning process or the post-death administration process, not knowing, so what am I getting into? This is the roadmap, and so they see the starting point and the ending point and every step in between. So it helps bring a clarity and comfort to clients. So with that said, I guess at this point I'm going to turn it back over to you, Courtney, for a couple of housekeeping, and then Courtney, if you could let us know if anybody's asked any questions.
We do have some questions. Let's go ahead and get those pulled up so I can go ahead and ask them for you. I may ask them a little out of order because one of them is up on the screen right now. So one of it is by Angie, and it says, how easily can I reach out to an attorney or paralegal to speak with someone?
Oh, well, that's easy. Well, I guess you've got the screen up there. And Jeanette would be the one to take that initial phone call. She I think on certain of these issues even knows more than I do. So yeah, so be contacting Jeanette at that number.
Yep, you can reach us at the phone number, or you can go to the website and take a look. And on that website, we have a feature called Book a Call. You can book a call through there, and we can get you into the right hands. So one of the other questions is, what type of property is subject to probate?
What type of property is subject to probate? Okay, that's a good question. So not every asset, if you will, property is subject to probate. And so examples of assets that are not subject to probate would include, let's say an asset is held jointly between 2 people. If it's held in the correct type of joint ownership, because there are basically 3 different types of joint ownership, 2 of the 3 will mean that that asset does not have to pass through probate. So that at the death of the first joint owner, so if we're talking about husband and wife, for example, at the husband's death, it will pass to the wife straight away. No need for the to involve the probate court. Of course, the risk there in saying, well, I own everything jointly with my spouse, for example, so I don't need to plan, is number 1, what would happen if both spouses pass away together? Sort of car accident, plane crash, and I know the odds of a plane crash are low, but what's the fatality rate in a plane crash tends to be high. And so So in that case, everything that both spouses have together would have to be go through the probate process. But even if that doesn't happen, and then one spouse passes away and things go fairly smoothly at that first death. Well, now let's fast forward to the second death. What happens? Not so smooth and easy at that point, unless some additional planning is done. Additional planning is done. So, so again, jointly held asset at the first death. Secondly, if there's an asset that is held that passes by a contract, what do I mean by that? By what we call designating a beneficiary designation. So things like life insurance, things like annuities, things like retirement accounts, IRAs, 401ks, that sort of thing. As long as the beneficiary designation form is filled out and filled out the way that you want, it'll go straight away to that person. Of course, we had that one probate case that Jeanette mentioned where the IRA was there, but there was no beneficiary designation form. Now, of course, even though those assets can pass outside of probate, there is the additional question is, okay, well, how is it passing to them? Is it passing to them outright? So it's going to be dropped in their hands and off they go, where it might be exposed to their potential creditors in their lifetime. What might that be? Well, an adult child's potential credit, the biggest risk to an adult child's inheritance are getting divorced, they get divorced, or getting sued from a car accident, divorce and lawsuit. Well, if the inheritance is coming to them outright, it's exposed to that divorce or that lawsuit. So there are ways that we can protect that inheritance. Remember, I said the 4 questions you can answer in a trust are who gets your stuff, what they get, when they get it, and how they get it. The how question is as important as the first 3. The how question is as important. So even though you may have assets that can avoid probate through the beneficiary designation, that needs to be taken into account with broader planning to say, okay, that's fine, but I'm concerned about my son getting divorced. So is there a way to protect that life insurance payout or that inherited IRA so it's not going to be exposed to the divorce or the lawsuit? Good question, though.
Okay, another question is, what if someone is mishandling the estate? So what if that person who is in charge of the estate is mishandling it? What happens?
Well, so, money does funny things to people, and we've seen this, haven't we, Jeanette?
Yeah.
A family member feels disaffected. You recall any situations like that?
Yes, I do, as a matter of fact. Do you want me to tell the story, the real quick story?
Sure.
So our client at the time, he was in Michigan, and his father, who was legally a Florida resident, owned a house down here, had moved up to be with his son in his final months of life, and had shared with his son a lot of his financial issues, or not issues, I should say, financial assets. So the son had information and access to these assets. Well, when Dad passed away, he again didn't have a will, but that was okay because it was just our client and then his brother, who were equal inheritors of his dad's estate. Well, as time went down the road, after our client was appointed as the executor of the estate by the court, we stopped being able to get a hold of him. He wouldn't answer our phone calls. His emails bounced back. He would claim that he had been hacked and his phones and his car had been taken over by somebody. And it got to the point where we had to withdraw from the case because we couldn't represent him if he wasn't talking to us anymore. And so that was granted by the court. And then along comes his brother, who's now got his own attorney. And it turns out that our client had embezzled about half of the assets in the estate, just taken them for his own, because he thought he was entitled to them or something. And that's an indication of what happens when something goes wrong. So now original brother that we were representing, to my knowledge, although we're not in the case anymore, doesn't have an attorney representing him, and his brother does. And the first brother is in big trouble because he's now personally liable to pay back everything that he took from the estate from the date of his dad's death.
Yeah,
and
that
it's not small potatoes. It's like $250,000 that he took.
That was a tough situation. That really was. And so I guess, Angie, to your question, if let's say brother is appointed as the executor and is handling the estate, but then sister feels that brother isn't treating her right or is hiding things or whatnot, is mishandling the estate, then sister basically needs to get a lawyer of her own to represent her interest. And at that point, it becomes a mess. It becomes a mess.
Big
So
mess.
good question.
And very much more expensive.
Yep. Any other questions, Courtney?
Yes. So I had one. Gary said, I had to take a call, so I missed some of the Q&A. No problem. Would it be possible to share this webinar with customers to create a need in the mind of the customers? Yes, we will be sending this to you. I'll take this question. We'll be sending it in 72 hours, within 72 hours, because it is being recorded. If you want to share it with your clients, you're more than welcome to share it with your clients. We'll also be putting it on our YouTube page and, of course, our Facebook page as well once we go ahead and get it uploaded. So you're more than welcome to share it, Gary, with anyone that you feel would be needing this information. So there is that. And then there is, what if any debt can be defaulted upon death? What responsibility does the beneficiary have regarding sole debt that I occur? And that is from Chad.
That's from Chad. Okay.
Accrue,
So,
I'm sorry, I said occur.
Yeah.
Accrue.
So the answer is, again, debts have to be paid first. Creditors have to be paid before distributions are made out to the beneficiaries. Okay. Now let's say that does not happen. Creditor is intentionally not paid, or maybe the executor or even the trustee of the trust pays the money out to the beneficiaries too quickly. And again, that's the pressure that sometimes we get, by the what's called the fiduciary. I want to distribute the money out because my siblings are pounding on my door and they want the money. Well, so then what happens if the money's distributed out, it's gone, beneficiaries have it, and they're off to the Bahamas? And now the creditor appears. The executor or the trustee, in the case of a trust, they have personal responsibility. And while they might then try to chase the beneficiaries to get the money back, good luck. So it is a very sort of serious role and serious undertaking to be what's called a fiduciary. That's the generic term for either being an executor or a trustee. Very important that you do things right and you do things the right way and get the proper help, because you have personal liability if you don't do it right. Okay, let's take one more question, Courtney, and then we'll let everybody get on with their day.
There actually is no more questions, so we can let everybody get on with their day.
Okay.
I'll go ahead and explain how, once again, you can get in contact with us. That way they can call, or if they want access to this, like I said, you can go ahead and visit our website and go to our book a call feature, or you can call the office directly. So thank you for coming.
By the way, there's our team. As Courtney said at the beginning, I work with 4 other women, so please pray for me. But no, in all seriousness, it's a great.
You're lucky enough to work with 4 women.
I know.
Exactly.
We like to call ourselves Team Legacy, and so there is the rest of the team rounded out. So, so if you were ever to come visit with us, I'm sure you'd see one, if not all of them.
And the last thing I want to mention is that during this time, it is a harder time for you to just come into the office and talk to us and see our smiling faces, but we are offering virtual calls. So we can do everything that we do in the office virtually through a virtual meeting. We use GoToMeeting, so it's very simple. Just like logging onto the webinar, it's very simple to log into our meetings, and Bill has adapted quite well in presenting his
Most of the time.
presenting his information to the clients, and we are able to, of course, tap in anyone into the call that needs to be into the call. So if you are a financial advisor and you have a client that is wanting a meeting and they want you there, of course, you're more than welcome to join that virtual meeting too. Hopefully soon we'll be able to see you back in the office, but once again, thank you for spending the morning with us.
Have a great day, everybody.
Bye.